Can you just speak to kind of like why you think it's important for lawyers, folks in the legal industry to be innovating?
Well, I think that we're an old profession. Law is an old profession and a conservative profession. So the interest and the incentive that we have to innovate comes from the outside. And by the outside, and the we, I should be clear, I mean law schools. So the incentive to innovate comes from the demand and the pressure, good pressure, that comes from legal employers, by which I mean everything from the biggest law firms in the world to smaller firms and businesses that are asking us, and in many respects demanding law schools, to train and educate students for a dynamic, changing profession. And that means, as I understand it, two fundamental things, and they're different. One is to develop within law school, in a steady way, the practice proficiencies, the competencies that will enable students to thrive in their early part of their careers, when they're going to be facing different challenges enabled in many respects, constructed by technology, by the forces of globalization, by economic pressures, and a litany of concerns and considerations that are causing firms and clients, big corporations, small startups, and the like, to demand not only more efficiencies from their lawyers, but different kinds of skills. The second and important imperative, and the reason why we innovate and must innovate, is our students are going to have careers over the trajectory of a long period of time in which the world will change in unexpected ways. And because it will change in unexpected ways, we're giving our students the architecture to innovate over the course of their careers. So although it's sometimes a trite used phrase, we're trying to develop an entrepreneurial mindset. Not because our students are going to all go out and be entrepreneurs, but they're going to need to develop the kind of entrepreneurial skills that will enable them to pivot, to adapt, and ultimately to lead in the profession.
So I'd like to ask about some things that make you hopeful, but then also obstacles that we need to overcome. But can you maybe first talk about things that you're seeing happening that have been happening recently that make you hopeful about us being headed in the right direction in the legal industry?
So there are a number of things that give me hope and confidence that we're moving in the right direction in the legal industry. One is, and this may be a sort of an odd way to put it, is the economic pressures that ultimately generated the if not the collapse, then the setback in the economy, now nearly a decade ago, created, to use the phrase that's either associated with Bill Clinton or Rahm Emanuel, depending on who you believe, never let a good crisis go to waste, is we use the crisis of that particular period of time to reboot, in many respects, the educational model of law schools. Now, I don't want to exaggerate that. We didn't reboot it nearly enough. And the period of time, now roughly 10 years from the setback of the economy, has been, in many respects, the heyday of law school innovation. And I think that 10, 20, 30 years from now, we will look back at this period as a very critical period in which law schools, combined with other parts of the academy, combined with law firms, forged the kind of collaborations that yielded some significant value in innovation and in collaboration. So what gives me hope about the short-term future, and frankly about the long-term future, is we're now set on a course of collaboration and innovation that's really hard to arrest and hard to stop. There'll be different kinds of changes and different kinds of curricula, and we'll continue to debate and discuss what exactly we should do to the business model of law schools, educational model of law schools, and certainly those discussions will persist in the profession. But we're all, to some degree, innovators now in our thinking and hoping about our business model. You also ask about challenges and obstacles, and there are some. And it's a long list, so let me give you a short list. I think one of our fundamental obstacles comes from sort of nothing succeeds like success, from the fact that legal education is still fundamentally, let me rephrase that. The legal profession is a guild. It sets a set of parameters and thus limits on what we can do as a law school to train professionals. So to give you some examples, we have to, at the very least, educate our students to enable to pass a bar exam. And it's unbelievable in this day and age, but there still are 50 states and 50 bar exams. And so the expectations of what law schools need to do to prepare their students to reach that place in the guild actually create some constraints on law schools innovating in very different ways. The ABA section on legal education, despite some significant reforms over the years, still imposes significant regulatory burdens and barriers on law school innovation. So I'll just give you an example. A law school that might want to shift its educational model to rely to a much greater degree on practitioners and folks in the real world in teaching classes and developing innovation are limited because of the caps on the amount of credits that can be allocated to adjuncts. Or suppose a law school wants to develop a very different model, so it's not 3 years with the expense and the time that goes into that. We're also not permitted to do that. So there are regulatory burdens and barriers and obstacles. The last one I'll mention, to shift away from law schools for a moment, again, I'll come back both to the American Bar Association, but also frankly, legislation and state bar mandates limit the ability of our legal ecosystem to innovate in profound ways. There are many examples of that. One is the restriction in the United States, as you know, on alternative business structures for law firms. Unlike in the UK and Australia and some other countries, that provides, again, another constraint on the kind of innovations that might generate true progress in what I'm calling the legal ecosystem.
So can you tell us just a little bit about you personally, how you're a very passionate advocate of innovation and technology. When did this come about? How did it come about?
So I'm passionate about legal innovation, but not because of any great expertise that I have personally and professionally from working in the marketplace. There are many, many others, whether you're talking about law tech, or you're talking about the economics of large law firms or what have you. There are many others in the profession, I'm not trying to be overly humble in saying this, who have greater expertise because they've been in the trenches and worked with law firms. What I have on offer as an academic over the course of about a quarter century of a legal career that has consisted of full-time academic teaching and writing, and also being a dean now for nearly 14 years at 2 different law schools, is a connection between the academy, the ivory tower as it were, in the law schools of which I've been privileged to be a part, and the profession through the work I've done with alumni and engagement with law firms. So I wouldn't say that I had a light bulb moment in any respect, but over the years, particularly over the last few years, it's become crystal clear to me that our educational model needs to evolve, not only in the law schools I've been part of, but in all law schools. And the way it needs to evolve fundamentally is in a direction that de-silos the professional education and legal education, and that fundamentally we need to give our students in all of our nation's law schools a appreciation for and experience in working at the intersection of law, business, and technology. If I have a single message that I'm the most passionate about, even though I know it's a bit abstract, is that the multidisciplinarity of professional development and the attention that law schools should pay to looking outside the scope of the traditional practice of law is absolutely essential and imperative. And I think that we can do as a collective in legal education, but also in our own individual law schools, is to push that agenda in ways that are appropriate for our marketplace and for our student bodies.
Can you tell us just briefly kind of about what your philosophy has been at Northwestern as you're building this this new curriculum as you describe it?
So my philosophy at Northwestern, let me start with the most abstract and get a little more specific. My philosophy about our law school at Northwestern is that we should aspire to be and continue to be both distinguished, with all that means as an elite law school with an extraordinary reputation that has persisted long before I came and will persist, God willing, long after I leave. It's a century, more than a century old law school, that we have a distinguished reputation that involves all of the legs of the stool, our teaching, our scholarship, our professional service. But we should also be distinctive. And those two things go hand in hand. So that we should not rest on our laurels, but we should be thinking about developing and advancing a curriculum and also extracurricular work that really advances the ball in the provision of legal services. It's not just about giving our students better, more innovative, more dynamic education, although of course that's our core mission. It's also from the vantage point of a very high-profile law school of advancing thinking and practical work as well as theoretical work that advances the cause of that we all consider valuable, and I know you consider valuable, which is access to justice, a more efficient delivery of legal services, a greater responsiveness to clients, the ability of our students to become better advocates and better counselors, and also generating through the work that students do along with faculty is providing the research, the thinking that will advance our understanding of what the legal profession is about and how it contributes to a civilized society. I'm passionate not only about the work that we're doing in law schools. I should say I'm also passionate about law and the rule of law and the imperative and the essential connection between what we're doing in our nation's law schools and what we're doing to advance constitutional values in our society.
What about as far as at Michigan State? So, and starting kind of with Joan Howarth had the vision to kind of get started with the Reinvent Law program, and then we've got the LegalRnD program. Kind of, what have you seen as the contribution to this kind of ecosystem, and what would be your observations on the value of the LegalRnD program?
So I've been a big fan for a number of years. I'd put maybe that at about a dozen years of the incredible work that's being done at Michigan State Law School in its LegalRnD program and its Reinvent Law program. One of the wonders, of course, of modern technology and the internet is I've been able, like so many others, to be consumers of the wonderful videos that are put out through Reinvent Law, of the scholarship that's been put out by a number of faculty members, including some faculty members, frankly, who are no longer part of Michigan State. But the combination of the folks who have come through the Michigan State program as faculty members, the vision that the former dean had, Joan Howarth, and a vision that I certainly hope and expect will continue on into the future, has put Michigan State in a unique position as leading innovation with a very small handful of law schools, hopefully that over time will grow, that has really doubled down on the idea that what students need, what law students need in our modern day and age, is exposure to innovative thinking, some deep and broad exposure to legal technology and to the business structure, and to borrow a phrase that one of the alums of the Michigan State LegalRnD program memorably described, T-shaped lawyers. I think it was an alum of the Michigan State program who wrote just a wonderful short essay several years ago that's still memorable, that talks about the advantage of T-shaped lawyers, which, as you know, involves a depth of knowledge, a foundational knowledge in legal skills. That's the column, but also a breadth of exposure to a knowledge of skills across disciplines that really helps law students prosper. So there's nothing proprietary in any important way about the work being done at Michigan State in particular, but again, as a first mover and as a leader in this space, it's contributed an enormous amount to what all of us in the legal academy at many other law schools are aspiring to do and thinking about doing to advance the causes that we consider important.
So yesterday you saw presentations from 23 students on 8 projects for outside law firms, Perkins Coie, Davis Wright Tremaine, Ackerman, and also Michigan Legal Health. I mean, what did you think about what you saw yesterday as far as what those students presented, what they produced?
So in the course of this conference, I did have the opportunity to listen to a wide variety of presentations from students. And I should say at the outset, it is not uncommon, particularly in recent years, to have student presentations in the form of these various innovation labs, including one that we have at our own law school. And all of those kinds of student engagement and presentations are valuable wherever they're found because of, frankly, the benefit to the students of having practical experience and actually putting their ideas into motion. Having said that, what was really striking to me about the presentations I heard yesterday in the program that comes out of LegalRnD at Michigan State is the partnership that had developed in the course of this particular scheme with law firms and the defining of the problems around law firms and legal organizations in guiding the students toward a particular solution, and also the use of a very, what I'm persuaded now, is a very interesting and effective tool, which is Neota Logic. So what I'd say about that is, in contrast to a number of other innovation labs where we're sort of creating ideas almost as heuristics, right, to enable the students to work on particular puzzles, like in the olden days when I was in law school, moot court, right? You develop a problem that may be completely made up in order to demonstrate particular skills. But unlike moot court, unlike the work that students do on journals, unlike a lot of the extracurricular initiatives in law schools, what the presentations yesterday revealed is that actually students benefit the most when they're actually working on real problems that demand real solutions. And we know they're real problems because law firms and legal organizations crave the opportunities provided by students to actually devote some sustained attention and focus on those particular endeavors. And at least as I could discern, now I wasn't part of one of those legal organizations, but at least as I could discern, the firms that were involved in these, some of the nation's leading law firms and organizations, were thrilled about the contributions and the work that the students were doing under the supervision of faculty.
So I said the other day that we're part of this guild, we're part of this profession, we've got certain privileges of having this monopoly, and we need to do more to hold ourselves accountable to make progress on these things we talk about, access to justice, civil, criminal justice system, things like that. I mean, so what do you think leaders in the industry need to do? I mean, sometimes I see these articles like, we're searching, where's our Elon Musk? Or it's like, how do we, I mean, that does seem to be a problem maybe, that there's not someone kind of like really kind of laying down the challenge and saying, we must do this and we're going to hold ourselves accountable for doing it.
So you ask about leadership in legal innovation among law schools and thought leaders. I think a number of us are thought leaders, and we're found in different places. Often we're found, as I am, in the ranks of deans, and that doesn't create any special authority because we're deans, so we should be listened to more closely. Although sometimes in our own organization that comes with the authority. It's more about the bully pulpit. It's more about the experience that academic leaders, in particular law schools, like in law firms, have as a result of their ability, my ability, to speak out, to be engaged in these debates, to go to conferences, to write articles, to generate videos, and all of that's very valuable. But at the same time, we need more than just a few. It's not where's our next Elon Musk, where's our next Steve Jobs, as though that from the head of Zeus, as it were, there will be a cluster of ideas that will capture enormous attention and ultimately adoption. It's got to be a combination of folks working collectively from the legal academy in tandem with folks outside the legal academy who are idea generators, just as we know from design thinking, who generate ideas, who are not afraid of failing, who prototype those ideas. Developing a curricular reform is a form of prototyping an idea, experimenting and developing where we can natural experiments, and also looking at things comparatively. I want to say, I hope this is not a tangent, I want to say that although much of the focus, the relentless focus in innovation, focuses on the American legal system, I've been struck in recent years about the supply of really interesting, good ideas from our partners in other countries. What's going on in London and the United Kingdom is worth some serious attention. What's going on in Australia, elsewhere, provides some contributions from the vantage point of folks who are looking at their legal infrastructure, and we know that the world is increasingly borderless in terms of economic value. So I find some of the most fulfilling interactions and exchanges that I have as a legal academic, as a dean, with colleagues that are working in other systems and are working in some cases in other countries to generate these particular ideas. Now, having said all that, your question focuses on when can we move from this ideation part to actually implementation, and who's going to push us in that direction. And I believe in the market to this great extent. I believe that the marketplace, that is the demand on the part of students and the profession, are ultimately going to wake us out of our sleep or to put it less provocatively, are going to nudge and in some cases push us toward making more substantial, quick innovation. Because if left to our own devices as academics, this could be a decades-long project. But if instead the students are telling us, law schools, you need to change to meet this demanding new marketplace. If legal employers are saying, you need to produce T-shaped lawyers, and here are the competencies that generate those kind of lawyers that can provide value, then the law schools that are prepared to adapt more quickly, not rashly, but quickly and on the basis of data, on the basis of their best assessment and all of that, will be the ones which thrive. And we're all in a competitive business. So if we're able to thrive as Michigan State has been able to thrive, as a number of other law schools, I think my law school at Northwestern has been able to thrive in that environment, then other law schools will take that to heart, and I think that adaptation will happen as a result of the market. I prefer that model to either the model of regulation, where some entity like the American Bar Association or state bars tell law schools what to do. I prefer the market model to the idea, the head of Zeus model, right? That one or two leaders sort of push schools in that direction. I think that we'll ultimately vote with our feet, and we'll do so in a way that will redound to the benefit of not only the legal academy and our own self-interest, but to the profession.